Senator Inouye.
I thank you, Mr. Chairman. Clearly, we have before us today a very distinguished panel of our colleagues and others who are interested in the subject of this hearing. I'll make my remarks brief because there will be sufficient time for all the witnesses. Mr. Chairman, I've reviewed the statements that have been submitted to the committee before we closed up business last evening, and it's clear that while this hearing is on the federal recognition process, a number of witnesses are actually more concerned about tribal gaming. Accordingly, I think it is important that we note the record for a few facts. The Director of the Office of Acknowledgement will present testimony this morning, and I would guess that he can more thoroughly document the facts that we discussed at our last hearing on this matter. And one of those facts that I recall is that a larger number of petitions for acknowledgement that are now pending in that office were filed long before the advent of the Indian Gaming Regulatory Act or the Supreme Court's decision on Cabazon. I think it is important because there are some who have suggested that tribal groups have petitioned for federal recognition for the sole purpose of conducting gaming. However, if this were so, we would have to attribute to many of the petitioning tribal groups their clairvoyance, that they knew that one day in the distant future there was going to be a Supreme Court decision, and thereafter the Congress was going to enact a law authorizing and regulating the conduct of gaming. So they decided that they would file a letter of intent to begin the process of seeking federal recognition. And those that believe that the process is too slow, too expensive, and too cumbersome, in that latter group, I would suggest are many, if not most, of the tribal petitioning groups. Should the fact that a state has recognized a tribe for over 200 years be a factor for consideration in the acknowledgement process? I would say definitely yes. How could it be otherwise? Don't most, if not all of our states, want the federal government to recognize the official actions of a state government? When most of our states want the federal government to defer to the sovereign decisions and actions of those states over the course of their history? I think the answer to that question would be decidedly in the affirmative. So let's be clear about one thing. The federal acknowledgement process is all about the recognition of the sovereignty of native nations that were here long before immigrants came to America's shores. It is not about gaming. The fact that pursuant to a law enacted hundreds of years later, in 1988 to be precise, affords to tribal governments the option of conducting gaming as one tool in developing their economies, it does not mean that every native government will, in fact, exercise that option. In fact, most native governments have elected not to pursue gaming. Let us not lose sight of the realities in a rush to judgment on the viability of a process that is clearly distinct from the issues of gaming. And I thank you very much, Mr. Chairman.
Thank you, Senator Inouye. The state of Connecticut is well represented here this morning, and I would like to thank all of my friends from the House as well as my colleagues from the Senate for being here. And I'd like to mention that the Attorney General of the state of Connecticut had requested to appear here today as well. We didn't receive his request until late. We received written testimony from him, and we'll invite him